I'm Stephen Lee Morris. I'm the executive editor, I was going to say. I don't know what I'm doing anymore. Executive director of LA Stage Alliance. And before we begin this, I guess, information session and town hall on the theater and the law, I wanted to thank the Casa 101 for hosting this event, particularly Emmanuel Deleage and Edward Padillo. Thank you so much for offering your space. I'd also like to thank our partners, California Lawyers for the Arts, particularly Alice Reeb, who helped set up this evening. And I have a couple of disclaimers that anything you hear tonight, please don't take as legal advice. These are ballpark suggestions and templates for guidance, but every case has its own idiosyncrasies. So what might be an answer for one situation may not be the same answer for a different situation based on differing circumstances. So these are just more general guidelines that we're offering tonight. And also the opening presentations by our panel of experts is being filmed, but we can post that. We'll be posting that on the website. But when we get into a question and answer session afterwards, the filming will stop, so both you don't feel constrained in the questions you ask, and they don't feel constrained in their responses. So by way of introduction, why are we doing this? We got, about 4 months ago, an SOS email from Berkeley, California, from the Shotgun Players. This is by we, I mean the LA Stage Alliance. And they said, we've undergone an audit and the result has been brutal. This is from the EDD, the state EDD, the Employment Development Department. And they said, we've been ordered to pay $50,000 in back taxes and plus penalties for the last 3 years because of the way we were alleged to have misclassified workers, which is the core of what we'll be talking about tonight. Apparently all their independent contractors were ruled to have been actually employees. That's what the state said. And they were in the process of beginning an appeal to question that. And they asked, is anybody in Southern California suffering the same fate? And we said, no, that's not a problem down here. We've never heard of such a thing. And then 2 months later, we got another SOS email from Casa 101, this theater we're at, and they're saying, we've just been audited by EDD, and we've been, it appears that all of our actors and designers and everyone else, just like in Berkeley, have been, we've been told they were misclassified and they should all have been employees. Now this gets doubly complicated because Casa 101, like so many of our theaters in Los Angeles, operates under the 99-seat plan. So the question of what is a volunteer, what is an employee, and what is an independent contractor gets very, very thorny here, and is at least partly related to the litigation that's currently going on between members of the Actors Equity Association and the union. What we're here to discuss tonight is really 3 questions. What causes an audit? Is there a relationship between EDD and the IRS and very possibly AEA, since we're going on with acronyms? And the third question is, how can artists and theaters protect themselves from being stung in this way? So with that, I'd like to introduce our panel. Directly to my right is James Counts. He's a CPA and CTFA since 1993. He's been the liaison for the California CPA Society to the California EDD. He meets with the IRS monthly at IRS headquarters in Washington, D.C. to discuss issues affecting California CPAs, and he's part of the IRS Security Summit to help identify ways to combat ID theft and to protect the tax system. And to Mr. Counts' right, we have Andrew Turney. Andrew is a partner in the law firm of McDermott, Will and Emery, and is based in the firm's Century City office. He focuses his practice on areas of corporate securities, mergers and acquisitions, corporate governance and finance, as well as assisting clients with commercial contracts and transactions. Andrew has gained some knowledge of the California EDD audits of theaters in conjunction with his pro bono representation of an LA-based nonprofit theater, which happens to be the theater we're sitting in right now. Andrew currently serves on the board of directors of the California Lawyers for the Arts. Welcome, gentlemen, and thank you so much for being here. Would like, for the structure for the evening, I'd like each of them to make a brief presentation, maybe 15 minutes or so each, and then we'll open it up to questions and perhaps deeper exploration of the statements that they've made.
So, me first? Okay, sure. Okay, what I want to try and cover in a period of time is why you need to get it right, because I find this in the beginning, what's the consequences if you don't get it right, to get your attention. Because sometimes people, when I cover the details, they sort of put it out of their mind and it doesn't apply to them. Why does EDD audit a business? And I'll briefly explain the types of audits that are created. And then briefly go over, if you get audited, what's the process? Some common misconceptions about who is an IC. IC is independent contractor or an employee. Factors to consider if a worker is an IC or an employee, and then I'm going to offer some resources. First of all, to get it right, my understanding is most, if not all of you, are officers and directors of a nonprofit. The State Attorney General says nonprofits do not pay fines and penalties. Those that cause the problem pay the fines and penalties. And that's defined as the officers and directors, because there you have a fiduciary responsibility to do things correctly. So as an example, if you do not treat someone as an employee when they should have been an employee, and you get audited and the organization penalized, the organization doesn't pay the penalty. The officers and directors or a donor may donate money to pay the penalty, and if they do not get a tax deduction for that. If an independent contractor is reclassified status, the business pays the prior taxes that should have been withheld from the worker's paycheck. As you're aware, normally employees are having Social Security and Medicare taxes withheld, state disability, and then maybe federal and state income taxes. Those taxes, in effect, the business would have to pay, and you're not entitled or legally allowed to go after the worker and say, hey, we need you to pay us back for these taxes we should have withheld from you. It's not allowed under California law. Why get it right? To continue, the business would be held liable later for also workers' comp. What if a worker got injured? Now there's no workers' comp insurance for that worker, and so the organization could be made to pay for the injury. Overtime may have not been paid that should have been paid. The worker may have not taken rest and meal breaks, so there are penalties that could be assessed by the labor commissioner on that. The worker may not have been given a pay stub showing what was withheld from their pay. And so if that happens, there's a penalty for that. And plus there's a series of other miscellaneous penalties. And keep in mind, these fines and penalties are paid by the officers and directors. They also could be held liable for benefits they did give to workers they reported as an employee. So yes, say you had workers that you paid for medical insurance. Now these reclassified workers from IC to employee, they were not offered medical insurance, and so you didn't pay for them. And now what if they had medical conditions that they had to pay bills out of their own pocket? They will come back at the organization to ask for reimbursement for all of these bills they had to pay themselves because you didn't give them medical insurance when they supposedly should have got it when they became an employee. Also, retirement contributions. If you should have a retirement plan, no matter how small or little it's put in, the workers, if they would have been qualified, will be looking for the contributions plus the income it could have earned while it was in their pension plan. So these are just some of the things you got to worry about. Why does EDD audit a business? Over 50% of the audits every year EDD does is because a worker files for unemployment benefits or disability insurance benefits, and EDD does not have a record of wages being paid that worker. And so what happens, tax branch of EDD will go out and audit the business, trying to determine was the worker a true employee or they did not qualify to be an employee. And if so, like I said, over 50% of the audits. EDD may find a business because of the underground economy. They have sweeps they will do along with other tax agencies, and they go to a certain area of the state, and they'll walk in every business and take a look, and if it looks like you've got workers, they'll ask for your EDD account number and other information to see if you're reporting them as an employee. If they think you have employees, they have the right under workers' comp to shut the place down immediately, because if you do not have workers' comp insurance. It's not unusual for somebody to refer to EDD a business because they say that they are not treating their workers correctly. It could be another tax agency. It could be your neighbor that you've been talking to that says, hey, no, we don't have employees. We have independent contractors. EDD gets copies of information filed on Form 1099 with IRS. 1099s are when you're paying an independent contractor. And EDD will call up these businesses asking questions about the workers, what kind of work they're doing and so forth. And if in that quick interview they think it might be a possibility some of these workers are employees, that will cause an audit. I mentioned that other tax agencies. Now and then, the EDD will pick out an industry because they think they've got problems with the industry and audit that industry. In my contact with EDD, I've asked them if they were focusing in on the theater industry, and they told me they were not. So I suspect the audits that Stephen mentioned earlier were probably because workers filed for DI or UI benefits. It was not because they focused on the industry. Also, EDD will do random audits of businesses. And this is those that are reporting some employees, to, whether it's one or thousands. And the Federal Department of Labor requires them to do that. A quick overview of the audit process. You'll get a notice saying we want to audit you. If you've been filing quarterly returns on at least one employee, they can go back 3 years. If you've been reporting no one as an employee, legally they can go back 8 years. And that notice saying they want to audit you is a DE 996. If you get a form that tells you what the date and time of the appointment they made for you, that will be on a 996C. And then if you get a list of information they want you to have available, that's basically a 996D. When you get this notice, I highly advise, and I emphasize, I advise you, do nothing, make no contact with EDD, go to your tax advisor, and ideally someone knowledgeable in the EDD process. If you try and do anything with EDD, you've just increased your risk that you're going to be held liable. The organization's going to have problems because all of us, to some degree, have watched TV and watched movies, and they talk about the Miranda rights, so that nothing said before you read your rights can be used against you. You open your mouth the first time you talk to the EDD, from that moment on, everything you say can be used against you. And if you don't know what you're saying, the importance of it, you're just opening yourself up in your organization. The simple version of the process, you get the audit notice. You'll have several meetings typically. The auditor will every time give you a list of additional information they may want or questions they have and so forth. If the auditor believes some of the workers are independent contractors and should be employees, they will get information on the workers, and they will interview the workers without you or your rep being present. So the workers, are not concerned about you being there in the room or listening in while they talk to the EDD auditor. The auditor, if they think they found errors of any kind, they'll make a proposed assessment. If you disagree with the process, the first thing you would want to do is talk to the group manager, the supervisor of the auditor, to see if maybe you can convince their supervisor to make changes in the audit results. And then if not, then you can begin your appeal process. And I'll leave it to Drew here to go more into the appeal process, because typically by the time it gets there, I'm out of the process, because by then people will jump to a tax attorney to handle the appeal. Some misconceptions that are common, IC versus employee. Just because a worker in a business signs what is typically called an IC agreement, independent contractor agreement, it does not make that worker an independent contractor. The EDD or the IRS also is not part of that agreement, and so basically both agencies look at, you have to follow the law, the court decisions and so forth, and if you're following those items, and they qualify as an IC, they have no problem. But if you're not meeting those guidelines, then their view is that agreement means nothing. Just because competitors are treating their workers as ICs does not give you the right to treat them as IC also. You have to meet the requirement. Some of you may have heard there's a version with the IRS that if you are following what the competitors are doing, you may qualify for what is called typically Section 530. California EDD has nothing like that. Makes no difference what your competitors are doing. Are you following the law? And if so, then you'll be allowed to keep them as an IC. Some other resources here that I would mention. First of all, there are several pubs and forms available on the EDD website. I encourage you to go through those and look at the interesting ones. But also, there's a section of them called information sheets. There's one on statutory employees who, by law, they're an employee, and no matter what else you do, they're going to be an employee if they meet that definition of that type of employee. Types of employment. They define certain types of workers and give information on what they're required to be as far as in employment. Couple of categories in that area is they have a section for artists and authors, and then they have a section that's for a nonprofit organization. I would encourage you at a minimum to read those two sections to make sure you're meeting those guidelines in that regard. With that, I think I'll pass it on to Drew and let him cover his information.
Okay. Thanks, Jim. As Stephen said, I'm a corporate lawyer, not necessarily an expert in employment labor law. So I want to double make the disclaimer about legal advice. But I've been doing some work in this area and also working with other lawyers and law firms that are representing theaters that are undergoing, that are dealing with some of these issues. And so I'm going to walk through just some of what I've learned and give you a little bit of background on the issues involved here. I understand just about everybody here is involved with nonprofit theaters. Is that accurate? And are most of the production crews on performances? Obviously, a lot of theaters have maybe one or two or a few actual employees, and then maybe just by a show of hands, does everyone here? Is just about everyone at the theater performing on a volunteer? Do you consider them volunteers? Yeah. Okay. So really that's what this first slide is really about. And I'm not, my goal is not to make anyone an expert on this, but under the California Labor Code, there's an exception to what constitutes an employee. There's an exclusion for someone performing voluntary service for a nonprofit organization that receives no compensation, no remuneration, other than meals, transportation, other reimbursement for expenses they incur in conjunction with their nonprofit service. And there's guidance from the Chief Counsel of the California Division of Labor Standards indicating that it's really the intent. There's a lot more involved, which I'll go into a little bit, but it's really the intent of the parties that's the controlling factor. People understand they're volunteers and they're being treated as volunteers, which we'll talk a little bit about. Then that's going to be respected. It needs to be for some kind of public service, religious, humanitarian objectives and whatnot. And the theaters definitely come under this public service, or not definitely, but they understand they come under this public service exception. There's been a lot of scrutiny in recent years on volunteers. You've probably seen it in the news. I mean, a lot of businesses, particularly in this new economy that we're in, where people coming out of college are having trouble getting work, and so there's been increased scrutiny for profits, with unpaid internships and whatnot. So a lot of that's been cleaned up, and this is really not the same issue. So although that has gotten more scrutiny, it doesn't really impact the theaters. So ideally, a number of you that raised your hands, ideally the people at theaters that are performing services, actors, production crew and whatnot, they are volunteers and they should be treated that way. But a number of these cases, and I won't go into any specifics on Casa 0101, but a number of the theaters that have had challenges, the EDD has come out and said, well, these are actually employees, and they've applied this employee independent contractor test. So ideally, they're volunteers, and at the end of this, I'll kind of give you some very high level best practices, hopefully practical, just best practices to ensure that that's the treatment they receive. But the EDD has been going through this, is basically been looking at this independent contractor employee analysis, which Jim alluded to. As part of these audits. And they do, by the way, they do very detailed audits, interviewing different people, volunteers, independent contractors, employees, depending on how you want to classify them, putting a lot of time and effort into laying out, their reasoning for an assessment, a penalty in this area. So there's, I'll just go through this very quickly. I got a few slides, but I won't spend much time on it. But 4304-1 under Title II of the California Code of Regulations is basically sets forth the what constitutes or the criteria, the factors that determine independent contractor or employee. And then there's a code 4304-5, which some of you may be familiar with, which is specifically goes through the factors and applies them to artists and kind of gives guidance on what California views as the criteria for artists, because it is a little more complicated than a lot of other professions, and they do that for a number of other professions. So an artist is an individual who creates, performs, interprets works in the visual, literary, performing arts, and they basically, California says that under the code that governs this, they basically say that they look at the common law, which isn't very helpful. But then they in this code, which is up on the screen right now, these are the factors. I won't go through them, but they look at all the things, and a lot of you are probably familiar with this. They look at, is the person engaged in are they separately engaged in this activity in other contexts? Like, are they performing this service for others, not just say your theater? Does the work that they're doing require supervision? Are they doing, how much time? Is it a long-term thing, or is it just a small set of time that, they've been engaged to do something? Are there special skills required for what they're doing? That sort of thing. Are they paid by the time period? Are they paid by what they produce, et cetera? I won't go through all these, but these are factors that they look at. So for an artist, they look at, so this is 4304, and I'll just go through real quickly a couple slides. So some things they look at are you established in other businesses? And some things they look at, well, if an artist has, headshots and they hold themselves as just about all, and a lot of this I'm going to be speaking about actors, but it applies to other production crew and whatnot. They all have their own complexities, like people that do musical scoring or set design. There are special issues related to work for hire and some things that really distinguish them as independent contractors. But I'll mostly speak about actors mainly because that's one of the biggest, sort of the biggest areas. But there's any number of different members of the production crew, from producers on down to stage crew, have been impacted by this. But so they look at, are you holding yourself out? And a lot of actors obviously have headshots and are looking for other work as actors. So that's a factor. Do they perform services under the direction of a principal or without supervision? It's a little, all these you'll see, and I should have said that at the start, all these factors are what we say in the legal profession. I mean, they're facts and circumstances dependent. It's really, a lot of these, as I go through them, you'll see, you could kind of see it either, argued either way. Is there a high degree of specialized knowledge and skill, techniques, artistic processes, methodologies unique to the performance of the arts? So high skill, if you can demonstrate, and I think most actors would agree, they bring a lot of skill to what they're doing. So that's a factor that makes you more likely to be independent if you're bringing a lot of skill. Provision of equipment, costumes, lights, stage, whatnot, whether you're bringing, it's kind of a classic independent contractor analysis, whether you're bringing these things yourself or whether the quote-unquote employer is providing them. That if you're providing your own equipment, that makes it more likely that you're independent. The length of time you're providing services, as I talked about, it's funny, most of the performance is obviously for a stage production, that is clearly a limited performance, so that's a good, generally good fact. Whether, again, related to that, whether the performance is measured by the work itself, production of the work itself, or it's measured by the day, hour, week, month, et cetera. If it's more of a deliverable, a discrete deliverable, you're more likely to be considered an independent contractor, whereas if you're getting paid by the hour, day, week, you're more likely an employee. Whether they're part of a regular business for the principal in this case. So theaters, it's a little complicated because theaters are obviously in the business of putting on productions. And so artists are obviously facilitating the core business of the theater and furthering those purposes. So that one's a little bit one that's tough. It kind of, that's a difficult prong. And all these are factors. None of these are clearly determinative of the status of an employee or independent contractor. The belief of the parties is important. If someone thinks they're an employee, and what's interesting too is, when I've read some of the EDD audits, there's confusion sometimes. Sometimes people think that they're, some are clear, I'm clearly a volunteer. I understood, I've always understood that, and then others, maybe not so clear in some of these interviews. Another sort of a class, these all relate to control, so they're all sort of factors of control. So if the theater is exercising control over the performers, that's an indication that they're employees. And whether the services can be terminated at will, an employee, or an independent contractor, they might be terminated, but there might be some damages, if your contractor walked away, on the job, as opposed to, an employee, which would, in California, in most states, they're at will and they can just walk away. And then if there's a collective bargaining agreement, this plays into it as well. So that's all just a little bit of background about the factors. But I think these next couple slides are, I think, what's more interesting. So these are factors that the EDD noted in some of the audits that they've done. And again, these are primarily focused on actors, but there are other things with different production crew. One is that they looked at the LA 99C theater plan, and they said, really they were treating it as a collective bargain agreement, which it's, and I'm no expert on that, but it's not that. It's really just guidelines. But they looked at this and they said, oh, it's a lengthy agreement, and it covers all these aspects of how they do their job, breaks, stipends, how rehearsals, how much time there'll be for those, meals and whatnot. And they said, oh, this is clearly, governing how they, governing all the aspects of how they perform. So this indicates employment, indicates employee status. They also said artists are not in business for themselves. And in some of the cases, they cited a lack of experience. This is interesting. I mean, for some theaters, they have much less experienced performers, and others, they're more experienced. So that's something, and all these are really fact dependent. Some theaters are going to have different results. But this one I just thought was funny. Actors are provided with a script. Yes, that's how plays work, right? And they're given stage direction and whatnot. And so they, the EDD said, oh, that's evidence that they're being directed, or that they're under control. And the employer determined the rate of pay in accordance with the LA 99C theater plan. I would say, and I was just speaking with Gary Grossman about this before the program, and I'll talk about this more in my closing slide, but the stipend, which is under the 99C theater plan, is really, I think, probably the biggest issue and easy to fix, because that really is, it's a payment, as I understand how it works, it's a payment that's made, I think the idea was reimbursement for transportation and parking. That was kind of the idea, but it's paid as it's a stipend, and so it's not directly, it's sort of an estimate of maybe parking and transportation and whatnot. So it's not, so the EDD viewed that as a payment, because it's, as I understand, you do rehearsals, and then for each performance, you're paid this stipend. It's kind of a nominal fee for your performance. And that's, it looks like you're being paid, even though I think we can all.
But that's not, sorry to interrupt, but
Sure.
those stipends weren't determined by the producers, they were determined by equity. So this is actually equity's terms to the producers saying, hey, if you're going to use equity talent, this is what you offer. And that's minimum, that some houses pay more.
Right.
So is that still the employer, quote unquote, determining what the reimbursement is?
So EDD is looking, I mean, they're looking at it just in isolation. They're looking at, here's a theater that's paying all these, again, I'll focus on actors, just make it simple, but they're paying all these actors this, and it's obviously a guideline that the producer agreed to perform in accordance with, so the actors could work, notwithstanding the normal union rules. But so EDD is, they're looking at it, sort of with blinders on, if you will, and just saying the theater is paying these actors, these stipends, right? And so it just looks like pay. And I think in some cases, people have received 1099s, and so for all intents and purposes, it looks like pay, even though I think we can all agree in this room that it was really just a nominal payment to reimburse for expenses and whatnot. I don't think anyone would necessarily call that pay. Right. Yeah. Exactly. Well, hold on.
We can
go
do-
ahead.
Well, Stephen wanted us to hold off until the end on questions. I know Drew got sidetracked with the one, but because of the recording. So
good point.
unless you really feel it's a hot question that can't wait for a few minutes.
I'll be done in just like a minute or two, and I'll answer your question. I think. Anyway, so here are some just a couple other factors, kind of secondary factors that the EDD and some of the audits noted. They said they weren't as highly weighted, but they were also important. Employers were provided with, employers provided costumes to artists. Artists don't have a financial interest in the business, the performances, and they finally noted that they're not artists are not volunteers because they receive this or compensation in the form of this stipend that we just talked about. So I just based on what I've looked at and based on some of the preliminary discussions, and I know this is all evolving because there's some appeals that are going on with the EDD, and so all this might, more information might come out, and hopefully, and Stephen's been terrific about getting information out to everyone, and so, we'll update you with more information as we have it, but just based on the preliminary discussions that I've had, here are just some best practices, put that in quotes, but some protocols that would be a good idea to have, and a lot of your theaters probably have this already. One is a volunteer agreement, some kind of agreement that documents the status, and this isn't an agreement that has rights and obligations and whatnot, because then that starts to look like an employment contract, but really just some piece of paper that where the actor or other performers acknowledge they're performing as volunteers and kind of what the hopes and goals of the relationship are. Again, you want to stay away from sort of rights and obligations for them, but really just something where they understand, you know, there's an acknowledgement that they're performing as a volunteer. The other thing is no compensation, and this is the point that you just meant about the stipend. So no compensation whatsoever should be paid, including benefits in kind, you know, anything that could be viewed as consideration, as we say in the legal world, consideration, you know, getting paid for something. So avoid the stipends. Now reimbursement is okay, and so what we've talked to a couple of theaters about is having some kind of log for reimbursement of transportation and parking, and really trying to get it, end up in the same place as the stipends under the 99C plan, but actually have a log and document, you know, document that that's reimbursement, and it's actually tied to, you know, I live 10 miles away and I drive there and I'm parking, you know, around the block, sort of thing. And then finally, flexibility, making sure, and I think, and Steve and I have talked about this a little bit, I mean, under the 99C plan, I understand that there is flexibility, and if you have to leave for another, you know, an actual, you know, you get engaged, you know, to perform on a TV show or whatever it is, again, for an actor, you know, people accommodate that. And I think because people are volunteers, I think there's generally a accommodation. I mean, obviously, it's a production and everyone wants it to be successful, and so you don't want people leaving in the middle of it. But I think there is accommodation if you know, if people are sick or have other commitments or whatnot. So, but that's something for a volunteer you really want to be attuned to. So those are kind of best practices. I mean, it's pretty simple, really. But and I think the stipend is the biggest issue with the EDDs. It's really kind of the linchpin of the EDD's complaints against some of the theaters. So with some small changes and maybe some focus on ensuring that people are really treated as volunteers, they'll get that status. And I would say, you know, if you're not a volunteer, then you're kicked into this whole independent contractor versus employee analysis. And as I went through, I mean, there are all these situations where it cuts both ways, and you can make arguments either way. But I think we can avoid that, and I think for most nonprofit theaters, you know, you can ensure that you can ensure that the volunteers are treated as volunteers, and that you don't have any problems with the EDD.